Okay, I guess we're ready to start. My name's Merrick, Garland. Today we have a very impressive panel of lawyers who have thought long, I should say, and hard, and as you'll see, loud, on the subject of prosecutorial conduct and misconduct. Our plan is to have each of our panelists make a presentation of about 5 minutes. As an experienced operator of the red light, I intend to be a reasonably strict timekeeper. As an experienced interrupter of appellate argumts, though, I plan to give myself a little extra time to ask a question or two as the panelists go along. Then when that's over, I'm going to try to encourage some cross dialogue among the panelists, and that should last about 30 minutes, and then we should have another 30 minutes at the end for questions from the audience. Our panel, in the order of their presentations, are Ronald Rotunda, on my left over here. He is the Henley Chair and Distinguished Professor of Jurisprudence at Chapman University School of Law. Prior to coming to Chapman, he was a university professor and professor of law at George Mason and General Professor of Law at the University of Illinois. He's the author of too many books and articles to count, but the most relevant for our purposes is Problems and Materials on Professional Responsibility, which is the most widely used course book on legal ethics. Sidney Powell, on the far right here, has a law firm which he's the principal dedicated to federal appellate practice, principally in the 4th, 5th, and 11th circuits. She was an assistant U.S. attorney in 3 different districts, in the western and northern districts of Texas and the eastern district of Virginia. Ken Wainstein is a partner in the Cadwalader firm, focusing on corporate internal investigations and civil and criminal enforcement proceedings. In his previous lives, of which there must have been many given all of his titles, Ken was Homeland Security Advisor to President George W. Bush, Assistant Attorney General for National Security, U.S. Attorney for Washington, D.C., and an Assistant U.S. Attorney in both the Southern District of New York and the District of Washington, D.C., District of Columbia. Finally, Jim Dunlop. Jim is a counsel at Jones Day, where he represents organizations and individuals in criminal and civil investigations. Those investigations have spanned the globe, ranging from the United States to Latin America, to Europe, to Asia, and the Pacific. Jim is a member of the Chicago Council on Global Affairs, where he serves on the board of the Criminal Law Practice Group. So we will begin with our discussion of prosecutorial conduct and misconduct with Professor Rotunda.
Well, thank you very much. It's an honor to be part of this august panel, speaking before a very august audience. We start off with Brady v. Maryland, 1963. The court held that the prosecutor is under a duty, if asked, and they always do, to turn over to the defendant all material evidence that's favorable to the accused that relates either mitigating guilt or mitigating the punishment. In that particular case, the jury found Brady and a fellow named Boblet, his partner, guilty of murder in the first degree, sentenced to die. At the trial, Brady said, he took the stand. He said, yes, I was part of the crime, but it was Bobbitt who did the actual killing. And in summation to the jury, Brady's counsel said, Brady's guilty of murder, but he'd like mercy. He'd like to be life in prison rather than capital punishment. This is 1963, when Maryland would actually execute people. And the prosecutor, he's convicted, appealed. The Maryland court, affirmed by the U.S. Supreme Court, overturned the conviction. The prosecutor did not show him a note from Bobbitt in which Bobbitt admitted the killing, being admitted the trigger man. And the court says you've got to turn this over. Subsequently, the ABA put in this model rules of ethics, a rule which I think virtually every jurisdiction in the United States has adopted. And it says that the prosecutor in a criminal case must make timely disclosure to the accused of all evidence or information known to the prosecutor that tends to negate the guilt of the accused or mitigates the offense. It doesn't require that the evidence be material, just that it mitigates the offense or negates the guilt. And there are a lot of cases under this that show that you don't have to turn over evidence that doesn't relate to this but might be helpful to the accused. For example, the complaining witness died. You don't have to turn that over to the defense. He pleads guilty. That doesn't go to whether he's guilty, just how hard it is to prove the case. Or another one, the prosecution mistakenly destroyed some drugs as evidence. You don't have to turn that over. That doesn't prove he's innocent. It just means it's harder to prove your case. But what about when they have evidence that's mitigating? You'd think you'd want to turn it over. They don't. The we have Chief Judge Wolf in Massachusetts in 2009, federal judge said he listed at least 9 cases he presided over during the last 2 decades in which prosecutors withheld important evidence. Two of the most important cases, not in his district but elsewhere, is one in the District of Columbia involving Senator Ted Stevens. The DOJ report later concluded there were astonishing extraordinary lapses, including the willful concealment of facts and evidence that would greatly help the defense. And the report identified various people as central figures. They dismissed all the charges, but too late for Stevens. He lost his bid for re-election. What happened to the prosecutors in that case? Well, one was Catherine Rumler. She's now the chief White House counsel. Another is Andrew Weissman, now general counsel and deputy director of the FBI. He spent even less time in Benghazi than the agents investigating. And another is a former acting attorney general. In the Enron case on appeal, the court, the Fifth Circuit, said, yes, it's true that the prosecution did not turn over some notes by one of the parties, McMahon, who was pleading the Fifth and therefore wouldn't testify himself. And they said in their turnover that he didn't recall making a guaranteed buyback. That was crucial to the prosecution's case. They said Enron guaranteed they would buy back certain things, and therefore it was inappropriate to treat that as a sale when they were touting their performance to their investors. And that's not what he said. He said it didn't happen. And the court says, no is not the same thing as I do not recall. But said the court, it was cumulative. There's lots of other evidence that he was guilty. He certainly wasn't innocent in the sense of newborn babe, and he probably did something else wrong, if not that. Actually, they just said it was cumulative and therefore harmless. Now the problem is the prosecutors keep doing this. And when they're caught, we find the courts of appeals, I think sometimes stretching, but certainly anxious not to overturn the conviction. And they often find out it's not material. So what happens if you're the prosecutor and they discover this and they don't turn it over? Well, you could get promoted. That's what the Justice Department does for several of these people, but that doesn't seem to discourage the activity. I mean, it's the state's evidence, state's interest, the people's interest to convict the guilty, but not to convict the innocent. The ABA, in a formal opinion in 2009, noted the distinctions between Model Rule 3.8D and the Brady Rule. In fact, the Supreme Court did itself in an earlier opinion. They gave a hypothetical. A purse snatcher is the victim. The bystander identifies the defendant as the purse snatcher, but the prosecutor was aware that there were 2 other bystanders who could not identify the defendant in a lineup, and a confidential informant had named another suspect. The prosecutor pursued these leads and found out they weren't credible. Do you have to turn them over? Well, under the ABA rule, you do. That is, you must disclose the information. If asked, you must disclose it in a timely manner, that is, before the trial so they can pursue it, and that the prosecution is not allowed to ask the defendant to consent to nondisclosure in exchange for leniency at sentencing. This, I don't think, is all that difficult a thing to do, that is turn over evidence that's exculpatory. If it's not material, that means it doesn't help the other side all that much. The court says, and ABA opinions have said, you don't have to search voluminous case files unless you know the evidence is there. You don't have to conduct an independent investigation for exculpatory evidence, but if you know about it, you have to turn it over. This doesn't seem to me like rocket science. Here's a case from ripped from the headlines. There was an article about it in the Wall Street Journal, I think about 10 days ago, one in the New York Times a few days ago. This is a state judge in Texas. He was a prosecutor for 17 years, appointed by the governor as a trial judge. And a decade ago as a prosecutor, 17 years ago, when he was 25 years ago, that's 1987, he successfully prosecuted a fellow named Michael Morton for killing his wife. The prosecution did not turn over evidence that the 3-year-old son had told his grandmother that a monster killed his mother. And that supported the theory of the defense that it was an unknown intruder. Later on, when DNA got better, they examined a bloody bandana found at the scene, and it turned out that there was the blood of the victim, of course, and the blood of another man who was not caught at the time, who later went on to kill another person and who's sitting in jail. So after 25 years, they just released him. No foul, no harm, right? Thank you.
So before we move on to the next panelist, I'm sure that Professor Rotunda probably just misspoke, because the two people you were talking about, the White House counsel and the FBI counsel, they were in the Enron case, not in the Stevens case.
Oh, no, I meant Enron. I'm sorry.
No,
I
but-
didn't
yeah.
make that clear. Those two were in Enron. In the White House, in the Ted Stevens case, there was a report lambasting the prosecutors, much more serious than I think what had happened in the Enron case.
And let me just put one question to you. So after Brady in Kiles versus Whitley and Strickler versus Green, the court expressly held that to violate Brady, you have to not only not disclose exculpatory information, but it must be material.
And willful, yes. Willful,
Yeah,
willful and material, yes.
And do you think the court was wrong in that, or do you think there's a difference between what the constitutional standard should be and what the ethics rule should be?
Well, I mean, we often have rules of harmless error and so on in prosecution, and I don't criticize the court for saying that before we overturn a conviction, there had to be a causal relationship with that and the conviction. So if it isn't material, it isn't a causal relationship. If it's harmless, and there's a concept of harmless error, but I think the problem is that courts of appeal are stretching to find cumulative evidence, and if it's not all that material, why did the prosecution, who by hypothesis knows about this, willfully decide not to turn it over?
All right.
Basically, I think the thought is you have a few disciplined prosecutors. The judge finds out it was should have been turned over, but it's okay because it was material or it was harmless. The state disciplinary authorities can issue a public reprimand of that lawyer. You do that a couple of times, and everybody's going to be turning this over, and the courts of appeals will have an easier time of it. They won't have to be deciding Brady cases anymore.
Okay, Sidney?
The judge gave us the option of keeping our seats, so I'm going to do that in the interest of making this discussion a little more informal. In the Merrill Lynch Enron case, the prosecutors that include now Chief White House Counsel Catherine Rumler and General Counsel Deputy Director of the FBI Andrew Weissman actually yellow highlighted crucial statements by witnesses as Brady evidence before the trial, and then withheld selected yellow highlighted passages of Brady material from the presumably accurate summaries they were supposed to have produced pursuant to the court's order. Unlike the Stevens case, we could not even get a hearing on our motion for new trial in that case. And the Fifth Circuit's decision finds that they plainly suppressed evidence favorable to the defense, which meets the test of the ethical rules as a violation of the ethical rules, but held that it wasn't material, despite the fact that the prosecutors had told the jury 16 times in closing argument alone the exact opposite of the crucial evidence they withheld. And the Fifth Circuit admitted also that the evidence would have impeached two of the key witnesses in the case. So how that comes out as not material, only that panel of the Fifth Circuit can really understand, I think. Certainly no defense lawyer would agree with that. So I think the question for purposes of our ethical panel is, what are we going to do in terms of bar associations and our rules of ethics? Are we going to hold prosecutors accountable? Courts want to punt to the bar associations, and bar associations and Department of Justice want to punt back to the courts and just say, oh, well, because no court has found that there's a Brady violation, we're not going to look into this. Well, if we're going to protect individual liberties, including those of every person in this room, we're going to have to take a stronger look at a standard to hold prosecutors to and enforcement of that standard. What happened to these Merrill Lynch defendants could happen to anybody. They served a year in prison on charges that did not even constitute a federal crime under the indictment as it was charged, because we couldn't get them bail pending appeal. They were all fine, upstanding citizens, one of whom Judge Werlein, who sentenced him, described as the most impressive person that had ever appeared in his courtroom and was just doing his job. but he went to prison for a year, denied bail pending appeal on an honest services charge that wouldn't stand up at all. So, you know, what are we going to do about these prosecutors? Are we going to apply the rules of ethics? Should the states start some sort of commission on a state-by-state basis, like Texas has a court of inquiry that's looking into the case that Professor Rotunda mentioned, and I think it may be the only state that has that process. But the state bar associations need to take this a lot more seriously than they're taking it now. Bill Hodes stepped up to the plate and filed grievances with me against each of the prosecutors in our case, and so far, Texas bounced it like a rubber ball and said the complaint didn't even state an offense, and the DC Circuit initially rejected the one against Ms. Rumler, but is reconsidering it now, and the others we haven't heard from.
All right, I think our next is going to be Mr. Wainstein, who will tell us whether all prosecutors are now conducting misconduct or they did it also while he was a prosecutor.
Yeah, I'll hold my breath.
Not sure I like either of those options. Did you get it? That's good. Good one. Fast hands.
I thought you were just clapping for it.
Anticipatory clapping. I was going to sit down too, but after hearing the substance of the last two speakers, I thought I'd better be on my feet so I can bob and weave. My name is Ken Wainstein. My perspective here is as a longtime prosecutor. I was in the trenches as a prosecutor for better part of 15 years, but also as the attorney who represents Joe Bettini, who's a senior 25-year AUSA out of Alaska, who's one of the people in the Ted Stevens case who's been sanctioned, preliminarily sanctioned by OPR, and that's actually going through litigation right now. And so I've sort of had the perspective of really dissecting that case and also sort of seeing the public's view of allegations of prosecutorial misconduct, the accusations thereof, and how those do or don't match the reality of what actually happens in the courtroom. Let me just sort of give an overview of my perspective on this. First, no question that any discovery violations by prosecutors, that's a problem. We can't accept any level of violations, but the reality is we'll never completely eliminate discovery violations by prosecutors for a number of reasons. One, and commentators have all remarked on this, you get it as your prosecutor, you're building a case, you get tunnel vision, you look at the case for purposes of deciding what is incriminating, and you often think only secondarily about what is exculpating. And so you sort of get that tunnel vision, and that's true, that's a problem, and that's something that prosecutors and their managers have to constantly resist. And so that's one of the reasons why these violations happen. And secondly, and relatedly, discovery is a human process. Prosecuting is a human process. It's done by human beings, and we make mistakes. Prosecutors make mistakes all the time, and being a prosecutor, especially in a high-profile case, is a tough job. You've got a lot of balls in the air, a lot of demands on your time, a lot of decisions to make, and sometimes you make the wrong call or you just miss it. The professor said that it's not rocket science to do discovery as a prosecutor. I'd take issue with that. It actually is very difficult because that's one of about 1,000 things you're doing under the scrutiny of a judge with often a very capable combative defense counsel snapping at you, which is what he or she should be doing. And you're also worrying about 15 witnesses and making sure that you're lining up your evidence and the like. And those of us, like Judge Garland, who've been prosecutors, can appreciate how it's actually not as easy as some might think from the outside. Look, my bottom line is, and I've felt this way now, and I feel this way now, I felt this way as a supervisor in the U.S. Attorney's Office, if somebody intentionally violates the rules, you got to throw the book at them. No question about it. They got to lose their job. They cannot represent the United States of America because of the damage that does to not only them, their case, but to the Justice Department as an institution. But I think if you look at the 70,000 odd convictions that we get every year in the federal criminal justice system, compare that to the relatively small number of Brady violations or Brady allegations that are alleged every year, you see how the vast majority of prosecutors don't do anything intentional, and to the extent that they ever violate Brady, they do so unintentionally. So the question, though, is, after Stevens and some other celebrated cases where these allegations arose, what should be done about it? And there have been a number of things floated, and one of them is to eliminate the materiality standard that we heard about and make it a requirement that the prosecutors turn over any evidence that is potentially favorable to the defense. without regard to whether that would be material to punishment or to guilt. And the problem with that, though, is that this standard, the Brady standard, and based on that case and its progeny, has, coupled with the legislation that's been passed over the last few decades, has resulted in a fine calibration of the obligations on a prosecutor to turn information over before a criminal case, recognizing that a criminal prosecution is full of very sensitive information, sensitive on a number of levels and for a number of reasons. And so these rules have been carefully calibrated. If you take that materiality standard and throw it out, you're suddenly opening up a whole new universe of information that a prosecutor needs to spend his or her time looking for and disclosing with ramifications. And just take a minute to think about what those ramifications are. And the Deputy Attorney General and others have testified about this recently because there's proposed legislation up on the Hill to do away with the materiality standard. One is obviously the witness security. I prosecuted cases where witnesses were murdered because they're witnesses. I had a witness murdered on the eve of trial and was up on the crime scene seeing what was left of her the day before she was supposed to testify. It happens. It's real. And then, of course, short of murder, you have intimidation, you have threats. That's real. That's a concern. Obviously, there are ways of addressing that, making exceptions, but that's something you need to think about. Secondly, witness concerns generally. It's not easy to get witnesses to testify in criminal cases. They don't like to. And they only do it often because if they know that the prosecution is going to do everything they can to protect their identity and protect them up to the very last minute. And if you now have a requirement that anything that's potentially favorable has to be disclosed, that expands the scope of what needs to be disclosed and therefore the number of people, witnesses, who need to be identified well before trial. And I can tell you, as one who spent a lot of time trying to talk witnesses into coming forward and testifying, that would make life a lot more difficult. Obviously, witness privacy, the more you have to disclose about what witnesses say, the more their private realm is disclosed, especially given that 90-some% of criminal cases plead guilty, so you're disclosing information about these private individuals, even though they end up not even having to testify at trial. Another issue that's been raised is national security cases. National security cases, especially terrorism cases, are built on very sensitive, often classified, but sometimes unclassified, but still very sensitive information about means and methods and sources and confidential informants and the like. And the more we have to turn over before trial, the more of that is disclosed to the defense and to the world. There's been a lot of talk recently about how more terrorism cases should be brought to the Article III courts and not sent to military commissions. And I can tell you, it's going to be an uphill battle uphill climb to try to get those cases sent to Article III courts if we now expand the breadth of information that's turned over and the insight that other people are going to have about national security operations in our pretrial discovery. And then I think the last point to think about before you were to drop the materiality standard is the amount of litigation that's going to spawn pretrial. You're going to have a lot more discovery litigation. Every factoid that's turned over that's potentially favorable is then going to be litigated as whether that factoid would add to another fact or could lead to another fact. And there's going to be a vast amount of litigation pretrial that we don't have now that's going to slow up the process enormously, expend resources, and it's also going to mean that the finality of convictions on the back end is going to be compromised because there are going to be many more Brady allegations floated afterwards asking for a new trial. So that's my concern about the proposed change to the law that's now being considered up on the Hill. And just very briefly, if that is a problem, what should be done? And I think the things that should be done are exactly what the Justice Department has announced is doing and has been doing for the last few years. Put a policy in place that tells prosecutors that they have to turn over anything that's potentially favorable to defense, regardless of materiality. That's the policy. Train to that policy. The department has all sorts of boot camps now and is doing refresher training, has a centralized coordinator who's focused on the training around the country. So you train to that policy, you manage that policy, you put it on the managers to enforce it, and then you enforce it. So when a prosecutor doesn't do that, you take them to OPR and you give them a stiff sanction. And if they do something intentional, they lose their job. And as somebody who's been going through the Stevens OPR process, I can tell you, the OPR process is real. It has teeth, and it hurts. My client can testify to that. So that, I think, is the way to proceed, and that's what the department has been doing. Lastly, the thing that you don't do, and this is where this is getting a little bit of my former prosecutor soapbox here, is you don't just have open season on prosecutors. And I know we're going to have a balanced discussion here today, and these are very good forums to think about this critical issue, and this is a problem. Prosecutorial violations of discovery are a problem. But one should not assume that because there are violations, there are always going to be violations, that prosecutors are, suspect for being criminals. I think of late maybe because of some celebrated screw-ups like the Ted Stevens case and others, some have felt emboldened to come out and accuse prosecutors of bad faith when there's no evidence of actual bad faith. My client in the Ted Stevens case was called a liar and a cheat and all these things as to particular allegations. Now, since they've been looked at, it's clear that the basis for those accusations to be a liar and a cheat are not there. But his reputation is still going to suffer from that. I don't know the facts of Sidney Powell's case, but I know that she has raised that case at 3 different courts and has been shot down each time. So maybe you don't have confidence in the courts, but the courts have looked at the facts and come back and looked at comprehensively and determined that there was not a basis for overturning the conviction. And that's the problem I see is that, unlike when I started out trying cases in criminal courts, there's a willingness now to use allegations of bad faith tactically and strategically. Tactically, in that a defense counsel can get up, and I am a defense counsel, so it's not like I'm accusing defense counsels of all conduct themselves inappropriately. But I think there's more of a willingness for defense counsels to get up and allege bad faith when they see that something wasn't turned over, as opposed to saying, hey, something wasn't turned over, that's wrong, I've suffered some prejudice, we need a remedy. Instead, it's, I haven't gotten something, the prosecutor intentionally tried to suppress it, when there's really no evidence of that. And strategically, I think we see generally a desire to try to keep prosecutors sort of knock them back on the heels by constantly hammering them for conducting themselves in bad faith in a way that there isn't any evidence to support that. So I believe that it's up to the judges to police that, to make it clear in the courtroom that you only bring those allegations against your adversary if you have the evidence to support it. And if you don't, then you argue out your case, you ask for a remedy, and you do so without impugning people's reputations unnecessarily and without basis. Thank you, Judge.
Thank you. All right, thanks to Ken. And our last batter is Jim Dunlop, who has a choice of sitting where he is or taking the podium.
I'm going to stay seated mainly to keep my head down between Ken and Sidney.
Standing is better for the audience.
I'm a defense lawyer in a criminal practice in Chicago. I've been a defense lawyer my entire career. I've never prosecuted. So my perspective is generally that of a defense lawyer. But some years ago, I was in the unique position as a defense lawyer to have defended one of several prosecutors charged in state court with obstructing justice and with misconduct for their alleged manufacture and suppression of evidence in their prosecution of defendants for the kidnapping, sodomizing, and bludgeoning death of a 10-year-old girl named Janina Carrico. It was a very notorious case. Our client, in fact, at the time he was charged, was no longer a state's attorney. He was an assistant U.S. attorney. And upon being charged in this case, was immediately suspended with pay. So the first issue, without pay, I'm sorry. So the first issue we had to deal with for our client was getting him his salary back so he could support his family while he fought these charges. Our client and his co-defendants, who were the other prosecutors and the police, were known as the DuPage 7 after the county in which they worked and in which the underlying crime took place. And I'll be referring to their case throughout my remarks. I generally want to talk a little bit about what I think is, sort of the right standard to apply in thinking about whether we discipline prosecutors and go beyond rectifying, as we should, the underlying case. And it's an unusual position for me to be in. I'm usually complaining about prosecutorial activity, as I did when I had witnesses and potential targets in the Blagojevich case. And the now former U.S. Attorney, Pat Fitzgerald, came out and announced Blagojevich's arrest by saying in Illinois that Abraham Lincoln would roll over in his grave at the political crime spree taking place. I thought that was an outrageous statement at the time. And now that he's not U.S. Attorney anymore, I can say it publicly. So as we've already discussed this afternoon, prosecutors wield unique power, and it's unmatched by most of their adversaries. According to the United States Supreme Court in Berger versus United States, prosecutors are not merely ordinary parties to a controversy, but they're representatives of a sovereignty. And we've heard about the ABA rules that apply especially to them in this instance. I think the Berger court set sort of an enduring standard for judging prosecutorial misconduct. It's the prosecutor's duty, it said, to refrain from improper methods calculated to produce a wrongful conviction. That has been determined to be a rigorous standard for determining whether prosecutors have fulfilled their duty and provides at least 3 elements which I think are worth teasing out and which I argue should have to be violated, should all have to be violated before moving beyond the realm of safeguarding a defendant's rights in the underlying proceeding, which is the least that can and should be done, and punishing prosecutors in ethical or internal or contempt, or in the case I'm going to talk about, criminal proceedings. First is the idea of the duty to refrain from improper methods. Whether a method is improper depends on the nature of the case and requires, according to Isaac against the United States and the Eighth Circuit, pronounced or persistent actions or behavior in preparation for or during trial where the impact of the misconduct is to distract the trier of fact and raise doubts as to fairness. A prosecutor who presents false evidence to the defense or the court assumes prejudicial facts not in the record or makes misleading insinuations, which was the Berger case itself, or conveys his own personal views. Those are all improper methods. And this is what was alleged to have taken place in the DuPage 7 case, and also certainly in more notorious cases recently, the Stevens case and the Duke lacrosse case. In DuPage 7, the specific allegation was that our client and other prosecutors had cooked up a statement by the underlying defendant, Rolando Cruz, that he had said he had a dream or a vision about the crime in which he relayed details of the crime that were not publicly known. And specifically what our client was alleged to have done was perpetuate the testimony of the police officers who said they had received that statement. There was also a charge that our client and another prosecutor had, before Cruz was retried, met with a lawyer for another incarcerated child killer, a guy named Brian Dugan, and received a hypothetical proffer, his attorney's hypothetical statement of a confession to the Nicarico killing. Berger sets forth also a notion that improper methods aren't enough, they have to be calculated. And calculated methods are not merely actions that a prosecutor takes in good faith, which happen to be frivolous, or even behavior that a prosecutor displays with reckless disregard. The methods are calculated when they're intentional, when they're deliberate. Cases since Berger have interpreted that to mean that a prosecutor deliberately uses such methods despite knowing them to be false. In the DuPage 7 case, it was ultimately this that led to the acquittal. It was ultimately the lack of actual knowledge that the dream statement was false that led to a directed verdict for our client at the close of the state's case, and an acquittal by jury of the other prosecutors, an acquittal that was so extraordinary that the jurors came out of the jury box and hugged each of the defendants. None of the prosecutors or the police were held by the court or jury to an affirmative duty to second-guess evidence brought to them by their detectives and agents, even when the dream statement emerged years after the crime or just before trial, and did not thoroughly match some later statements that were recorded. The police officers who told the story of the dream statement were acquitted, as I mentioned, and this was really a matter of credibility. The jury believed them and did not believe the underlying defendant, Cruz. The final element that Berger talks about is the intended consequence of the prosecutor's improper methods, namely that the conviction be wrongful. Here's a place where it seems to me we could use some clarity. The Berger court's formulation suggests that the mere use of improper methods does not by itself render a conviction wrongful. Otherwise, to modify a wrongful would be unnecessary. It seems that there must be something else about a conviction that makes it wrongful, something that would negate guilt or import so much doubt into a guilty verdict that a manifest injustice would obtain, that is in some way correlated to the improper methods that were used, something, in other words, that is game-changing. Should materiality come into play? Should it matter whether the concocted or the suppressed evidence in a case has diminished the exculpatory effect because of all the other evidence adduced in the case? As defense lawyers, I cringe and say absolutely not when it comes to rectifying the harm to the defendant in the underlying case, but I think I agree with Ken that as a basis for disciplining prosecutors, perhaps it should. This is essentially what happened in the DuPage 7 case with respect to the attorney's proffer that was withheld. The defense of the prosecutors on that point showed that after receiving the proffer and feeling themselves biased because they were about to retry this guy who had already been convicted, so they couldn't really look at the proffer clearly, the prosecutors invited the state police to conduct a completely separate and independent investigation that produced an 800-page report and reams of other evidence that included all of the facts that had been adduced in the hypothetical proffer, and all of that went to the defense. So the decision in the case, that the ultimate verdict, seems to be a judgment that the conviction here was not wrongful, even if probably the additional prior statement should have been turned over. There was also an added element of lack of calculation for our client because he had not been responsible for the discovery decisions. His colleague had made those, and there was a showing that the decisions had been made to streamline the case, not to deep six an exculpatory brass ring. So the question is really, what is the proper remedy for misconduct? Is it reversal of a defendant's conviction, or is granting a new trial enough? That may sufficiently protect the liberty interests of the wrong defendants, and it may avoid a potential chilling effect on the prosecutor's ability to pursue wrongdoing. But will it deter prosecutors from doing this? I think, as the DuPage 7 trial demonstrates, criminal sanctions are a difficult way of deterring, especially when the heat on one side of the issue is amped up by the notoriousness of the underlying crime. I think that we have to be really careful about, as a society, and we have to recognize the risk that was recognized in that verdict of taking the fog that applies in prosecutorial decisions just as much as it does when we defense lawyers put together a case, and turning it into a disciplinary matter where there aren't the elements of calculation, or where you can show that decisions have been made objectively along the way. And I think it's really important to remember that both the defense and the prosecution, as we practice as lawyers, we have a sort of muscle memory that we develop over years and years of cases, so that a disclosure decision in any given case that looks very subjective in the context of that case, I think is often for a prosecutor, and I think Ken will bear me out on this, is a product of a muscle memory and judgment accumulated over many cases. We don't want to lose that judgment on the prosecutor side any more than we do on the defense side when we fight these things. And so I would argue for a careful standard when it comes to actually imposing discipline as opposed to just undoing convictions. Thanks.
All right, let's start. So let's start the interactive round here by asking both Ron and Sidney this question. So what should we do? But to do that, we should talk about where we are already. So as Ken was saying, Deputy Attorney General Ogden issued a memorandum after the Stevens case saying that the policy of the Justice Department would be that disclosure must be made of any information that is inconsistent with any element of the crime charged, regardless of whether the prosecutor believes it's material or not. In earlier iterations, in the mid-90s, when there were cases involving problems, two amendments were passed. One is the so-called Hyde Amendment, which authorized the court in any criminal case to order the payment to a prevailing defendant of reasonable attorney's fees and litigation expenses, where the court found the position of the United States was vexatious, frivolous, or in bad faith. In the following year, in 1998, Congress passed the Mcdade Amendment. These, by the way, were both named after members of Congress who had been investigated. And that amendment says, an attorney for the government shall be subject to such state laws and rules and local federal court rules governing attorneys in each state where the attorney practices. So you have a Justice Department policy not requiring a strict adherence to the materiality requirement before turning over. And you have a federal statute providing attorney's fees when the government acts in bad faith. And you have another one saying that federal prosecutors will be bound by the laws and by the ethical rules of the bars of the states in which they are members. Is this enough? And if not, what more is required? Start with Ron.
Well, yeah, yeah, briefly, I'm not proposing a new law. I think we have too many laws already. I mean, Congress has been passing laws for 200 years. You think at some point it'd be done. But I'm just simply talking about enforcing the law we already have. The ABA rule, which I think every state has adopted, has a provision. I didn't read you the whole thing because I didn't want to just be reading things, but it says you turn this over except when the prosecutor is relieved of this responsibility by protective order of the tribunal. So if we have confidential sources that we're not going to use as witnesses, they might say something that is exculpatory, but we don't think it's worth it, you tell the judge, and just like in grand juries, the defendant doesn't get the information. When I referred to rocket science, it's not, litigating is far more than, litigating is like rocket science. That's why we get paid so much, thank goodness. But it's not rocket science to say if you come across information you think is exculpatory, that you turn it over. And in the case involving Enron, Enron, the court said that the appellate court said the lower court clearly erred in not requiring disclosure of the contents of this note. Now that to me is, the Court of Appeals already decided that. And then they said it was harmless and cumulative, and that may well be right. I don't dispute that. I do think that when the Court of Appeals decides that a prosecutor did not turn over exculpatory evidence, but for some other reason we will not overturn the case, that's something where the bar could come in. And I don't want to take this guy's house, dog, and car. I think a public reprimand is something that might be appropriate. And when that happens a few times, when you find willful information, willful misuse, that would be put other prosecutors on notice. I think we'd find a lot less of this activity going on.
Sidney, more laws or just more zealous enforcement or more sensitive judges or what?
I think it's going to take a combination of things. I think district judges need what Judge Sullivan called a healthy skepticism for the mantra of prosecutors that we know our Brady obligation and we've complied with it. That was replete in our case. It was replete in the Stevens case. It's typical in every courtroom across the country that I know of. And if the judge really knows the prosecutor and their local assistant U.S. attorneys, sometimes you know that that person's word is rock solid. But other times that's not true, and we need to be willing to look behind the curtain more often than judges do. In terms of the ethical rules themselves, bar associations really do need to step up to the plate here and do more investigation. There are not that many Brady claims filed in front of bar associations, and particularly not by practicing lawyers. They might be filed by disgruntled defendants, but I think the bar should take very seriously any complaint filed by another respected member of the bar alleging any sort of Brady violation, particularly when there is not only evidence of it, but there is yellow highlighted evidence of it that's directly contradicted by what the prosecutors repeatedly told the jury. I agree with Ken that there are cases, of course, I was a prosecutor for 10 years in 3 different districts, where you need to protect a witness or you need to protect Homeland security issues, as he is well aware. Those cases are more rare than they are the rule, and that can certainly be accommodated under an open file discovery policy that should be the presumption as opposed to the exception. There are districts where an open file discovery policy works, and people use the exceptions as they need to, but depending on the case and the judge.
So would you change Rule 16 to turn it into open files?
I would like to, yes.
Jim?
One of the reasons I had to reach back for a state case is that in the Northern District of Illinois, they have an open file policy, and these Brady issues are really quite rare. It makes the job of the defense a little bit harder. I mean, you really end up going over and plowing through a lot of things, and it becomes like a civil sort of discovery, and things aren't as closely tied together. But certainly, the defense bar in Chicago has been glad for that policy for many years, and glad when the office moved to that policy.
Ken, I'll give you a chance both to rebut and to comment on the open files idea.
Well, just on the open file idea, I mean, that's been floated as a way of addressing, as the panacea, that, okay, there's not going to be any discovery problem here. There are going to be no violations because the files are going to be available for the defense to look at, subject to the exceptions, like, as Sidney said, if there are witness security issues or national security issues. The problem is that it isn't necessarily the silver bullet, because it's not as though the sum total of every piece of information that is relevant to an investigation, to a prosecution, is going to be reduced to writing in a file. And so you can take the case file and give it to the defense counsel, and they'll know a good part of the story, but they won't know the whole story. So there's still going to be that analysis that a prosecutor needs to go through when they're listening to a witness. That witness might say something that's not reduced to writing. It's still incumbent on the AUSA to assess whether that is exculpatory information, whether it's something that needs to be turned over. So I think in the debate, some people sort of see the open file idea as being, the answer to everything, and I don't believe it will, because there's still going to be judgment calls that a prosecutor needs to make. That being said, I think in some places it has worked. And I know in some states it has worked, so I think it's certainly worth looking at.
So there's two arguments I've heard against open files. One is open files becomes the needle in the haystack without any winnowing. In fact, this was the argument in the Oklahoma bombing case, that government turned over so many statements in so many DVDs and CDs that the defense couldn't find the part that they thought was important. And second, that if you leave out the exculpatory and impeaching material, but just look at open files as a whole, you eliminate the possibility of being able to contradict a witness who is otherwise lying by some inconsistency either in the facts or prior statements or something else. And that since cross-examination is supposed to be the world's greatest engine for discovering the truth, you eliminate that possibility. Do you think either of these are worthy considerations, Jim, since you started talking about open files?
The needle in the haystack consideration, I think, can be remedied in extraordinary cases where there's likely to be an enormous volume of defense material, of prosecution material, like the Oklahoma City case, by courts that either allow more time for the defense or that appoint additional lawyers or that appoint forensic assistants and others who can go through some of that material and help. I mean, clearly there has to be reasonable capacity on the defense side to do that. But to say that it's just too much work to go through the amount of evidence that exists on the other side seems to me to be a little bit in derogation of the defense duty to do that. So I don't find that argument very compelling. I think, you know, one of the things that you said, Ken, I do tend to agree with, is that there are still lines that are drawn even in the open file policy, and the line that's drawn in the Northern District comes at agent notes, and agent notes often contain very useful information for the defense and contain those prior inconsistent statements that you could use. And so I guess I would say the problem is we're not getting those. If I were getting those, I think it would enhance my cross-examination ability.
What do you think about the inability to present material, not exculpatory material, but just material that's really inconsistent with a witness's claim that they did certain things on a certain day, which helps their case, and it turns out they didn't do those things on that day. They were somewhere else, which they would discover through open file, but they might not discover through Brady.
So impeachment information about the government witnesses that is made available to the defense because they now have
Right, but the
access to
government
open
doesn't
files?
yet know about whether it's impeaching or not because the person hasn't yet testified as to what their story is.
Right, well, I mean, obviously, the ability to see what the specifics of a witness's account and then go out and find potentially inconsistent information, that's exactly what defense counsel would like. So, I mean, that's the point.
Yeah.
That's the same argument, of course, that played out in the whole question about the Jencks Act. You know, the Jencks Act is that's the legislation that says that prosecutors must turn over to defense counsel any prior recorded statements of their witnesses that are relevant to the testimony of that witness. And the law says that those statements, so in prior witness statements, prior letters, whatever, have to be turned over to defense counsel after the government witness has actually testified and given his or her direct testimony. Now, I can tell you, if I ever tried to do that in front of a trial judge, you know, I said, you know, thank you, no further questions for this witness, and here, by the way, I'm giving defense counsel a stack of 17 inches worth of documents for him to look at during his break, the judge would have my head. So in practice, prosecutors almost never do it, but that's where the law came down. And the reason for that, of course, is to avoid witnesses being identified early on in the process, being subject to intimidation, et cetera. So the balance there about witness privacy, witness protection against defense counsel's ability to investigate the witnesses and find problems with their testimony was drawn by Congress in a way that's very, you know, favorable to the prosecution.
Let me put this question to both Ron and Sidney. Ron, because you've been looking at this for a very long time, and Sidney, because you were an AUSA during a period and are now defense counsel. So have things gotten worse? Have things always been this way? Is there some trend line going on here?
I think it's really hard to tell. That is, there's more things coming up now, but I don't know if because in the old days everybody was like Pericles and now they're corrupt. Or is it simply that we're just looking more carefully? I mean, the Ted Stevens case, as well as the Enron case, had involved significant personalities, in the Enron case, a lot of money. I mean, it's expensive to put on these defenses, and the average person just can't afford it. So it may be that in the past, we had fewer of these high-profile prosecutions. Remember, a lawyer told me once, he said, he did criminal defense work, white collar, and he said, I hope I never get into trouble because I can't afford myself. And that's just, I have no answer to how to solve that problem.
Sidney, was everybody like Pericles when you were a prosecutor? Are they now all corrupt?
No, but I do think it's gotten worse, and I think it's especially gotten worse in the more high-profile business cases. I think there's been an over-criminalization of business conduct and too great a willingness on the part of prosecutors who want to make a name for themselves to overreach either in charging decisions, evidentiary decisions, Brady decisions, whatever. It's just, it's gone too far. I know Department of Justice has made some effort to correct that, but I don't think the Ogden policy goes far enough by any means. It really doesn't have any teeth to it. It can be modified on a district-by-district basis. And the Department of Justice, frankly, if Judge Sullivan had not thrown the fit he threw and was prepared to dismiss the indictment himself, wouldn't have done the investigation that they did on those allegations. Our case alone proves that. So there's just a whole lot more that needs to be done about it.
All right, if anybody needs a rebuttal, they'll have a chance, and then we'll go to the audience. Does any start with Ron, and if any of you feel like you want more to say it, and if not, we'll switch on.
I'm done.
I guess it's, to your question as to whether it's worse, I mean, I don't think so. There have been Brady violations since the beginning of prosecution, and we all have made mistakes, and that happens, and I think the department is doing more. There's more of a focus to try to prevent those mistakes. I do think, though, that there is this is what I was saying at the end of my remarks, there's a greater willingness to now accuse with bad faith. And so that sort of ramps up the profile of these issues, makes them more controversial, and they get more attention. I mean, I often use the example in one of my very first trials back in New York in 1989. I remember doing direct examination on the case agent, and he recounts, let's say, 10 data points that the defendant had said, statements the defendant had said under Rule 16 that was supposed to be turned over. 3 of those 10 apparently had not gotten turned over. Defense counsel stands up and asks the judge, Judge, can we come to the bench? Go to the bench, and he says, Judge, I didn't get those statements. I'm sure it was an oversight. And it was an oversight. We had just messed up in the discovery process. He got the statements. We had some remedial steps put in place, and everything went fine. Nowadays, it's more likely that that defense counsel is going to get up and say that Mr. Wainstein's withholding or suppressing this. And I think that's damaging to the process. It's damaging to the cooperativeness that's at the basis of our criminal justice system. Yes, litigation is tough. It's adversarial. But it only works because we do cooperate together. And I think it also, frankly, it's making some prosecutors scared to take on some of these big cases, big, righteous cases that have, that are high profile, and the stakes now are personally very high for prosecutors because they can win the case and lose their reputation.
I think it's certainly going to make a prosecutor second guess in a high-profile case. I also agree with Sidney on the over-criminalization aspect of driving some of this, and I think if you want to hear more about that, you should come to our Criminal Law Practice Committee presentation tomorrow on the FCPA, where you'll hear a lot about that. I owe Rolando Cruz a mention. I owe him mention of his innocence. He was eventually acquitted, and I think it's important to note also, later DNA evidence established that he could not have been the perpetrator of the murder or the rape of Janina Carrico. And in fact, the incarcerated child killer, Brian Dugan, was convicted of that last year on the same DNA evidence. And so I just want to make sure that for the record, we mention the fact that that defendant was acquitted.
Sidney, you want a last word?
Yes, I think as a matter of law, the Brady standard needs to be reevaluated and materiality disentangled from the prosecutor's initial decision whether to produce anything. It is too easy for an unscrupulous prosecutor or somebody who just wants to win a little too much to say, oh, well, that's not material, when in fact a prosecutor is absolutely no judge whatsoever of what's material to the defense before a trial. And materiality was really, I think, intended to substitute for a harmless error analysis in deciding whether a criminal conviction should be reversed. And the Supreme Court's questions to counsel in Smith versus Kane imply that at least 4 of the justices thought that also.
All right, well, it was actually quite clear, though, that in both Strickler and in Kyle, that they were not, that was the argument in the case, that they should have that rule, that exculpatory should be the Brady violation. Harmless error should be what happens if there is a Brady violation, and the court rejected it. It is quite possible, though, that the court will come a different way, and one of the defense counsel in this table may bring that case. And there will be the opportunity. There was, by the way, cert was just denied this week in
And Shaken.
Shaken, which was a Hyde Amendment case. As I mentioned, Hyde is the case about getting attorney's fees for a vexatious, frivolous, and bad faith prosecution. Judge Pryor for the 11th Circuit said that has to be objectively bad faith. The cert petition sought to make it subjective, and the Supreme Court on Tuesday denied. So at least that issue is not going to go any further. But the Brady issue could, at any day, wind up before the court. Do we have microphones for? Perfect. Ask away.
My name's Jane Brown. I'm an AUSA from Kansas City, criminal AUSA, and I've been there 10 years. On behalf of myself and any other former prosecutors in the room, I'd like to say that I've never failed to turn over any Brady or Giglio material, and I believe that many others in this room could say the same thing. Here's my question. In fact, some on the panel advocated filing bar complaints against AUSAs or prosecutors who they believed had failed to turn over discovery or items. In the 10 years I've been doing this, I've had one case where defense counsel turned over discovery to me. In all of the situations where it was not turned over, there were items brought up during trial that had not been disclosed. Do those panel members who advocate filing complaints against prosecutors also advocate filing complaints against defense counsel in that circumstance? Thank you.
Well, I think probably Sidney and Ron will be the first people to answer that question.
My mother always told me what's sauce for the goose is sauce for the gander. So, yes, I think if people are hiding the ball, they should be held to account for it.
Yeah, and you know, I've worked with prosecutors for years, and on and off I've worked with prosecutors, all federal, and worked with defense counsel in criminal case over the years. I mean, I've never found a Brady violation, and I don't want to suggest that these things are endemic, it's simply, but even a small number is too many. If there's a way to reduce it, I don't think we'll have much cost. And in terms of filing these complaints, talking about a case where the court has ruled that there is a Brady violation, that is, there is information that is exculpatory and willfully withheld, and then affirms the conviction because it's harmless error or whatever. There are very few cases like that, and in some cases, the prosecutors get promoted. Well, you know, if they want to get promoted, I guess that's up to the guy that hires them. But if they had a public reprimand, that's going to make them a lot more careful, and that would be good. I mean, and so they're very, you know, I don't know if there are more Brady violations compared to the past. All we know about the ones that have been disclosed, but the ones that are disclosed are really kind of bad.
Ken, why don't you talk about the OPR process a little bit? Ron raised the question about public reprimands. That's the way the department deals with public reprimands of prosecutors.
Yeah, the OPR process is something that's been subject to scrutiny over the last 5 or 10 years, and some people out there have suggested that because we haven't seen a lot of AUSAs getting fired, that the OPR process must not have sufficient teeth to it. And I think that's really not the case. It's really what Ron's saying, is that you just don't find willful violations. Willful violations. You find mistakes, you find oversights, and the like, but not willful violations. And it's hard to tell an AUSA, look, you're being fired. We're going to ruin your career because you made a mistake. And OPR doesn't do that. So I think actually the OPR process does have a lot of teeth, and I got the teeth marks on me from going through the process most recently in the Stevens case. They do a thorough, they see that there's a lot of attention being paid to the Brady issue specifically. They did an unbelievably comprehensive review, many 100-page report, talked to my client for days, and the other individuals for days. And, they put out a report which I disagree with. I think their decision was wrong about the finding as to my client, which is that he was not intentional. He didn't intentionally violate Brady, but he was reckless in his exercise of his duties. And they recommended 45 days, which is a lot, and that's dramatically more than what has ever been recommended for such a violation in the past. So I think it's a very real sanction, and that's what the department wants to rely on, as opposed to having to rely, outsourcing that function to the bars. And because once that happens and that becomes the norm, then you're going to see referrals going the other direction, and then I think that's just not good for the relationship with the defense bar, period. Last point is, the department gets it, that they've got to deal with this issue, they're jumping on it, and they know that people are going to be watching the OPR process. So I don't think you're going to see a squishy OPR process or squishy OPR results.
Just add something to what Ken said. And this relates also to his earlier comment that counsel are quick to accuse other people of bad faith. It's not you made a mistake, you're an evil person. I have seen a lot more of that. I haven't done a scientific empirical study, but I read a lot of these cases. I talk to a lot of lawyers, and there's a lot more of that going on. The theory of Chief Justice Berger in creating the Inns of Court is if we all sat together and broke bread together, we'd be less nasty. Well, that doesn't, maybe we'd be nasty anyway, or even worse, but we just have a lot of nasty people out there. And I'd like to tell you it's going to get worse before it gets better. I just think it's going to get worse. It's not going to get better. I don't have any solution for that. I think telling lawyers be kinder and gentler is not going to work. I think that a lot of lawyers that make these, for them it works. That is, I've seen so many depositions where the lawyers chastise the witnesses. In one, this one wasn't on video, but the lawyer gets up and he starts walking towards the witness in a threatening way. So I said, I'd like the record to reflect that the lawyer is getting up and he's walking towards the witness in a threatening way. Well, that stopped it right away. But I've read a lot of depositions when I'm asked to work on the appeal where they tell me that happened, but nobody made the charge. Because the typical lawyer in a deposition of his client or a witness that the other person calls is kind of just sitting there drinking coffee. But so we have to be alert. But I don't have any simple way or even a complex way to reduce the antagonism. And I think people do it because they find that it works.
You have a question?
Yes, my name is Frank Marine. I'm a retired federal prosecutor with over 35 years' experience, and I think there are two issues that are related that the panel seems to have overlooked. First, you were all talked about how if the prosecutor has knowledge of exculpatory information, you should give it over. The standard is not actual knowledge, it's imputed knowledge. The prosecutor is required to turn over evidence in the possession of the prosecution team, even if he doesn't know about it. He's held responsible for that. The second related issue I'm going to elaborate in a minute is what constitutes a file. You seem to think one of two things. Either you go get this box, and there's this little document, here's the file for case X, or you could Google everything, and it's all on a computer. Well, that's not in the real world. That's not after all these years in the past. Computers didn't exist. Today, the FBI system is still not up and running. You don't even know what a file is. I'll give you an example. I did organized crime cases. You could be investigating the Gambino family in New York, and there could be two material witnesses in Kansas City, which not only the prosecutor doesn't know about, but the FBI agents would have known about it because they were interviewed in a different case. They weren't indexed. You can't research paper files by name like you can do a computer. You can only search indices. So you have no way of knowing whether that person was ever interviewed unless you got lucky. And yet, the prosecutor could be held liable because he is liable for the prosecution team, none of which you had discussed. The easy cases are there. Yeah, Somebody said he didn't do it. It's in my file. Well, any moron knows that's exculpatory. But most of the stuff is impeachment materials. I'll give you a concrete example which ruined a good friend of mine's legal career. He was over 45 years as a prosecutor. It was an organized crime case in California. He does research a file, finds that one witness who he wasn't going to call testified at a public trial, okay? Doesn't turn it over. Well, the defense attorney goes and gets the file, found out that he was a witness, uses it for impeachment. Judge dismisses the indictment. The department disciplines the prosecutor, who frankly forgot he ever read the transcript, and yet he's imputed, it was knowledge of him, it's imputed that he should have turned it over, even though the defense attorney already had it. So you can come up with wacko examples that a prosecutor violated his duty, and of course, with 20,000 prosecutors around the country, with over 100,000 prosecutions every year, of course you can cherry pick some bad examples. But in the real world, I have no idea what's in most of the files. I'll give you another example, informant files. There's a lot of damning evidence in FBI informant files. There is no way a prosecutor, when I was there, was going to get access to it. I fought a lot of battles, lost most of them. Sometimes I won them. But yet, everything in that file is imputed to me. Now, how would you like your ticket resting on what some FBI agent determines is exculpatory? And while we're on the subject of truth, which is supposed to be a trial, supposed to be a search for truth, why not impose a reciprocal discovery rule on defense attorneys to turn over all inculpatory information as long as it doesn't come from the defendant? I'll grant you the Fifth Amendment protects that. But what about witnesses? You find somebody who said, yeah, guess what? The defendant was there when I saw him. Oh, but you don't have to turn it over. Oh, because this is the Sixth Amendment right. Oh, yeah.
I'm talking about the ABA rule. It says, quote, a prosecutor needs only to disclose evidence of or information, only need to disclose evidence or information of which he has knowledge, end quote. And then they define knowledge as actual knowledge. When we're
That's
talking
not
about
what the case law does. And
no,
while
the
you're on
case law.
subject
No,
of
excuse me. You can interrupt me when I finish the
Go ahead.
sentence.
All
All right.
Go ahead.
But then it's not interruption.
I apologize.
Yeah. No, the case law is talking about the Brady case. I'm talking about the ethics rule that came from Brady. In some respects, it is broader. It doesn't require it to be material. In other respects, it's much fairer to the attorney because it requires actual willful knowledge. That's what it requires. There's no imputed liability. There's no guilt by association. So if the attorney doesn't see this stuff because it's in Kansas or he doesn't have a computer, that's fine.
Are you finished? Everybody else was talking about Brady, and that is the standard for Brady. And while we're talking about the ABA, I'm glad you brought that up. Who the heck is a bunch of Brahmin defense attorneys who have self-interest? Where do they get the authority to regulate the sovereign government and exercising their governmental capacities? It's one thing. Congress wants to make rules. I can live by that. Court wants to make rules, I can live by that. But a bunch of defense attorneys that I'm not even a member, they're going to tell me how I have to govern myself vis-a-vis them? I don't think so.
Well, the rule, that is the ABA proposes a rule, just like you and I can. We have a right to petition the government for redress of grievances, and then state courts adopt it by rule. I refer to the ABA because it is the model rule. And in some cases, there are, just like with the uniform laws, there are states that adopt the uniform law, but with a non-uniform amendment. And so it is with the ABA, but as far as I know, every state has adopted.
What about the Supremacy Clause? If the Supreme Court has decided as an interpretation of federal law that X is the standard, why should the ABA be allowed to circumvent that by doing it under the guise of an ethical rule, which is inconsistent with Supreme Court cases?
Well, actually, there's an answer to that, you see, because the ABA proposes to the state court adopts it, and then Congress passes the Mcdade law. So we have completed the circle.
But the
And
Mcdade law does not
says-
govern discovery.
No, the
Mcdade law
McDade-
governs civil suits.
No, the Mcdade law says that federal attorneys have to follow the state ethics rules. The state ethics rules say that prosecutors must turn over exculpatory evidence of which they have actual knowledge. So that's how the circle is completed. I mean, I just talk about the
What's your
world, which
view
is
of the
not
Brady
my-
rule on imputed knowledge? Do you think that should be changed?
Well, no, I think
get it.
I think the purpose of the due process rule, which is where the Brady rule came from, is we do not want to convict people who we think might be innocent or at least not guilty beyond a reasonable doubt, and therefore we should reverse if the exculpatory evidence is not harmless error. But if it is harmless and it doesn't affect the result, we don't overturn the conviction.
Does anybody else want a chance?
I just want to jump in and say I hear a lot that there ought to be rules about, reciprocal rules for discovery for the defense, and with respect to the idea of identifying your own inculpatory witnesses, I think among other things, the Fifth Amendment's active production doctrine would cover that. That's kind of a Brahmin defense notion, but I throw it out there.
Next question.
Yes, I'm Bill Hodes. I worked with Sidney Powell on the appellate aspects of that, the last piece of the Enron case, and I was for 20 years a law professor specializing in legal ethics. And I want to make one comment looking backwards, and then a comment and a question as forward as to how we deal with these issues. The backward-looking question is to remind us all that, as the last exchange showed, as we sit now, there's a disconnect between the constitutional rule, I also taught con law, between the constitutional rule for what it takes to overturn a conviction or habeas corpus or whatever it is, and the ethics rule which is imposed upon prosecutors after it is later discovered that there was what I call a real deal Brady violation, not a mere clerical error, but a deliberate, knowing attempt to hurt the defense by knowingly violating. Now, I believe that that it won't be long before the materiality requirement will be taken out of the initial part of Brady, because it just simply is unworkable to put, for all the reasons that Ken gave and Sidney both, it's unworkable for the prosecutor in the midst of a case to be able to figure out what is going to be exculpatory, because they don't know what the defense case is. And even the most honest prosecutors have the tunnel vision that was discussed. So the rule is going to be somewhat similar to what the Justice Department now says rule is going to be, which is basically we turn over everything. I'm not sure of the difference between open file and if we see it and it's exculpatory, including for purposes of impeachment, which is part of the Brady rule, then we just turn it over. And then if it later turns out that something wasn't turned over, and which, by the way, we have no idea how many cases there are when that was asked of Sidney and Ron, we don't hear about the cases. Don't know how many there are. My guess is that there are, in fact, quite few, that most prosecutors do it just about right, but we just don't know how many. But then, then later, when you decide the remedy, you decide how important it was it material, was it harmless error, or whatever. But looking backwards to the cases, in the old era when there still was this disconnect, it really does seem to me to be imperative to say that if there are rules which have been adopted not by the ABA, but as Ron just said, by the Supreme Court of each of the states, and then made binding on federal prosecutors and others through the Mcdade Act or the Mcdade Amendment, then it has to be treated seriously. And the real difference between the Brady rule as a constitutional rule and the disciplinary rule in all of the states is that there is no materiality requirement. And therefore, if you have a deliberate case in which a prosecutor is known to or is later proved, to have deliberately taken, has not given away, has not turned over clearly exculpatory evidence, whether it would have been material or not, that has to be treated seriously. Now, that blends to the future. As I think Sidney mentioned in passing, we filed charges, disciplinary charges, because we thought we had something like 20 exhibits that we filed in New York, D.C., Texas, and then with OPR as well, on the 4 prosecutors involved in that case, showing the actual grand jury transcripts and other information that the prosecutors had, that they had highlighted, and that were not turned over. In Texas, we were shot down immediately. In D.C., we were shot down, but now they're reconsidering it. And going forward, though, what I want to say is we just learned today that the other case from Texas that Ron mentioned about a 25-year-old prosecution, that case is going forward. There was a case in Louisiana in which a prosecutor who admitted on his deathbed to another prosecutor that he had hidden evidence. He died, but the other prosecutor was brought up on charges for not disclosing it about the other one. That's for those who know what the rule book says, that's a Rule 8.3, a mandatory report situation. In D.C., where we are still in the process, they are actively bringing charges against a former U.S. attorney here in D.C. In a case in which the whole argument was it material or not material? And so my question is, or comment and also question for reaction is, going forward, if we, taking Ken's point, which I absolutely do, that you must limit it to what I call the real deal cases, that it should be a situation in which really the only way to stop this is, however large the problem is to have high profile, not just reprimands, but serious consequences. And I'll end just with one little anecdote. In the legal ethics bar, I'm for some reason, most are heavily liberal. I'm known as the somewhat more conservative end of it. And when the Duke rape case came down, and the prosecutor there was rightfully disbarred. I mean, he had done not just Brady violations, but he had lied to the court and he had fabricated evidence and so on. When he was disbarred, on our chat group, a lot of people said, "Oh, big deal. They were rich white guys, and they had lawyers, and so if this had been somebody else, then nobody even would have cared about it. They would have pled guilty, and that would be the end of it." And my response is, no. We celebrate that. The system worked. And yes, they were only able to get it because they were rich white guys with rich parents. But what we should work for is so that same kind of serious consideration of the Brady, the real deal Brady problems, that kind of remedy should be extended to everybody else. Not that there are 2 ways to even up the sides. You can bring down the Duke guys, or you can bring back everybody else who isn't the Duke guy.
Okay, thank you, Ed.
Just a brief comment. First of all, for those who don't know, Bill Hodes is the co-author of a treatise on legal ethics, which I think is very good. I would use it more often, except it competes with mine. And secondly, on the Mcdade Act, I'm not a fan of the Mcdade Act. That is, I think federal prosecutors should be subject to a uniform ethics rule and not vary from state to state, but Congress in its finite wisdom has decided the contrary. I think it's really much better to have a uniform rule with with a uniform ethics rule for prosecutors. But we have the Mcdade Act, and so I just talk about the state versions, there being no federal one except for OPR and the Department of Justice manual.
Okay, we've got about 8 minutes left. If everybody could, we'll stick with the 3 people who are up there. Try and divide the remaining time amongst you.
I think I'm just going to ask a relatively short question and not get into my own thoughts too much. But by the way, my name is Francis Menton. I'm actually on the committee along with Ron Rotunda and Bill Hodes that I guess sponsors this program. The topic of this is prosecutorial misconduct, but the focus of pretty much everybody has been Brady violations and discovery materials, particularly from the prosecutorial side. I'm just wondering if anybody on the panel sees any other significant areas of prosecutorial misconduct out there, and maybe there aren't any, and then maybe that would be a good idea, but or good news. That might be great news, but not that this is an area that I follow that closely, personally, but certainly somebody mentioned it. Patrick Fitzgerald's conduct, and I don't mean to stand up for Rod Blagojevich, but his conduct in making wild statements, convicting him at press conferences before the trial, certainly shocked me. But we got much better along the same lines in New York, where we had a guy named Elliot Spitzer, who famously would hold big press conferences, usually with regard to companies, never file the charges, continue an investigation for months and years, continuing leaks out of his office until finally there's a settlement of 100 and 200 and 300, in one case $850 million. Of course, he'd be driving the stock prices down during all this time. So there's just a couple of things that come to my mind, but I was wondering if anybody had any other examples or areas of prosecutorial misconduct that are significant.
Ken, as the former U.S. attorney, what was your view about press conferences announcing indictments or charges?
Yeah, that's a tough balance to strike as a prosecutor, that being how much and how to publicize what you're doing. And at the same time, keeping in mind that we have a system that presumes innocence until someone's proven guilty. And, you know, sometimes you strike that balance right, sometimes you strike it wrong. And keep in mind, there are very good reasons why we should publicize things. A, the public has a right to know what's going on in their criminal justice system. B, the public has a right to know that their public servants are doing good work and are out doing things. C, you need to get the deterrent message out there. One of the main reasons for criminal prosecutions is to deter not only the people, specifically deter not only the people you're prosecuting, but others out there. And so by getting the word out, that has a deterrent message. And 4 or D, I can't remember which scheme I'm on, but you know, as a U.S. attorney, you've got, in my case, 330 prosecutors who are working day in and day out in relative obscurity, and they do something well. You want to tell the world about it. I mean, that's your job, is to sort of publicly pat your people on the back. So there are a lot of reasons why it's important to do that. You always have to keep the presumption of innocence in mind. That's so important, especially before there's a conviction. And you also have to keep in mind that, you know, as a federal prosecutor, you should always err on the side of being reserved. You are sort of the guardian of the dignity and the respect that the department has earned over 200 years, and you need to keep it. And so you have to err on the side of being more reserved. And, you know, all the people we talked about here today are great public servants. Pat Fitzgerald is one of the finest public servants I've ever met. And, you know, we all sort of calibrate it sometimes on the fly, and maybe sometimes we make mistakes.
All right, second to last question.
I'm a state court prosecutor where, of course, about 97% of the criminal work in the country is done. And one of the things that has been a trend in state criminal law investigations is a proliferation of electronic recording of interviews between investigators and witnesses. And I think the federal government has been very resistant to allow that to occur. My understanding is FBI agents still do not electronically record interviews with witnesses. And a lot of these discovery violations that become Brady violations are fights about what's in that interview report. Does the interview report accurately reflect what the witness said? Then are the agent's notes discoverable? And wouldn't it be a significant improvement in the system if the Justice Department would do what, you know, frankly, my sheriff's office is doing and give detectives a $100 digital recorder and say, if you're going to talk to somebody on a case, you record it, we'll preserve it. We can litigate later whether that defense attorney can get access to it, whether it's material or not, but we're going to preserve a recording when we can of that agent's interview and eliminate a lot of these ambiguities. And then once you decide it's discoverable, then kill them with your open file and dump 10 CDs in the defense lawyer and let them find that nugget if they can.
Yes, that would help.
A defense lawyer who can bill for all that time.
Ken, what do you think?
It's a tough issue, and it's actually one that's, I know the department has been wrestling with for years, and the Bureau has been wrestling with the question of whether to mandatorily record all interviews. And there are a number of, keep in mind, the scenario you think of is an interview where you're in an interview room, there's an agent across the table from a suspect or a witness, and you're having a sort of structured interview, and all you have to do is just flip a switch on the wall and it'll be recorded. That's not always the case, obviously. A lot of interviews happen in the back of squad cars and dark alleys, and so you have to draw a line there. There's some vagueness there. And I think also, once you set the standard, you say the FBI says they have to do it. That means they have to do it with everybody, and if they don't do it, there's almost a presumption against them in any ensuing litigation. That also is the standard then that will be applied to every police department around the country, because once the FBI adopts it, every police department has to adopt it. So I think they have to think about the impact, the ripple effects that would have on other police departments. But you make good arguments.
All right,
I just wanted to add a slight defense perspective, not really to this last thing, but to something we were talking about just a moment ago, which is the role of the government in announcing charges and things like that. I mean, I do think that both in the turning over of evidence, which yes, we would all like to get all of those recorded. I guess what I would say is, if you're going to record statements, whether we should record all of them or not, please don't leak them when you announce charges, because that happens all the time in Chicago and elsewhere, and that can be very, very damaging to somebody who still enjoys the presumption of innocence. And I find it a little bit striking to think that the deterrent effect of criminal prosecution is supposed to be carried out through the announcement of charges as opposed to through the proving of charges and the obtaining of a conviction. I mean, I really think that's where the deterrent effect is most present and comes in. And I find completely an opposite the notion that the career aspirations or joie that individual prosecutors who've worked hard on a case might receive by being able to stand two people over from the U.S. attorney as he announces charges should be a basis for holding giant press conferences that impugn a citizen before he's been convicted. It seems to me a press release would do, a written press release in most cases would do.
Can I respond to that? I mean, I'm sure we'd say the same thing about pinning medals on soldiers. But, Napoleon said, give me enough medals and I'll conquer the world. And I think it's the same phenomenon. As a matter of leadership, it's really important that your people know that the product of their hard work, which is usually an indictment, is something that they should be patted on the back for. And you're right, you've got to do it without, as you say, impugning an individual. What you're saying is, this is the evidence that the grand jury has decided there's an indictment here. These are the charges. We have, and we're going to trial, and we're going to prove it up at trial. And you have to be very careful to say this person's presumed innocent. But I think it's as a matter of management, leadership, and inspiring people who do very hard work, often in a totally unsung way, it's important for the public to know the good work that they're doing.
Okay, last question.
Thank you. My name is Dan Hind. I am a state trial judge in Texas. I handle mostly civil cases, so I've got a little bit of a different perspective here. In civil cases, as you know, both sides have affirmative obligations to hand over evidence to the other side, whether you call them disclosures or whatnot, or whether they're requested or not. But it strikes me that when I have evidence that a party has not fulfilled that obligation, I have a wealth of tools in my toolbox, short of filing a grievance with the state bar or prosecuting them for obstruction of justice, to ensure that that information is handed over. All I've heard today, however, is that we should send these immediately to grievances, or that we should somehow suspend someone from their employment. I doubt I've had any of those lawyers who've come before me on a motion to compel, and it turns out that they did in fact hold back information, lose one day's work from their employer from doing that. My question is, why aren't we talking about some of those other tools that we know judges have that are used in other cases without using them here in the criminal context?
Sidney?
Well, I mean, I guess we certainly could be, but I think the topic for the panel was focusing on the ethical rules and to what extent those need to be applied or handled differently. And then the Brady aspect. Ron, do you want to speak to that
Yeah,
more?
just briefly, because the hour is late, but referring to the ABA Model Rules of Judicial Conduct, which most states have adopted, there's a provision there for judges to refer to appropriate authorities, ethics violations of the attorneys before them. And when we're talking about civility in court, judges have a role in that. I saw one case where, I mean, it was party to one case where one of the lawyers was making his argument before the judge, and the other lawyer kept interrupting him, and kind of to lose the train of thought. And the judge just sat there quietly and let the two people do it. He had a role to take without disciplining anyone, just ordering the guy to be quiet. What I do know from empirical evidence is that while lawyers can do well by disparaging their opponents, they must treat the judge as God. The judges won't stand for that. And I think they have a role to play even in cases like Brady. For example, if the judge thinks that this is not simply, that even though it's not material, you're not going to overturn the conviction, but that the violation of Brady was particularly heinous, but for whatever reason he's not going to overturn, but it was very willful, he can send that to the disciplinary authority, or he could, or to the prosecutor's office to see what should be done. And they seldom do that. Now, in some cases, because state judges are elected, and they don't want to overturn the section of the only group that really pays a lot of attention to them. But judges have a role to play here with anything from collegiality to Brady material.
Yes, but I don't have to send to a grievance committee every time a lawyer interrupts the other lawyer in court. I can handle that in court. And that's what I'm asking. Where are the remedies within the court where this is happening? Why are we waiting until afterwards and going to grievance committees or getting people fired?
Well, we
when
don't
the
go to
judge,
grievance.
as you said, the judge can do something about it right there.
Because he didn't.
Well, I mean, he can send it to the prosecutor's office to try to find out why. You know, there was a Supreme Court decision that came from, Louisiana. The attorneys did not turn over exculpatory evidence. Plaintiff sues Connick, I think the father of the singer, and they wanted to get damages from the office and him. And the court said, I think correctly, they didn't have the right tools under 1983 because you've got to show a certain pattern and so on. But that's something where I would hope after that case, the head prosecutor did something about his office. And if the judge sends a letter or puts it in his opinion, the prosecutor's office should try to find out why this happened and make sure it didn't happen again. Usually the prosecutors they want to pay attention to what judges say. So they do have those tools. I've never seen a case where a judge has used it. Now, maybe it hasn't come up in any way that's reported, although Westlaw and Lexis do report a lot of unreported decisions. But I think that's a useful technique for the law already have. Thank you very much.
I think we've had a great chance to see both the arguments and passions on both sides, and I'll get in a lot of trouble if I don't let you go. Thank you very much.
It was a pleasure to